to you both, but we're going to bump you down and go to the next case while Mr. Smolker works on this issue. Okay, and the next case is Norris versus Rodriguez. See the attorneys, Mr. Seifert. You're up. How are you today?
Good. You?
Hanging in there. All right. You're up. Proceed.
Thank you, Your Honor. May it please the court, my name is Ray Seifert, and I would like to reserve 3 minutes for my rebuttal.
Sure.
To represent the appellant, Melanie Norris, in this proceeding. This is a unique summary judgment case. It's a premises liability trip and fall where the record evidence is uncontested and the parties filed contesting motions for summary judgment on liability. Central to this was where the fall occurred, who owned that land, and also who had possessory rights to the instrumentality that caused the fall. The summary judgment in favor of Mr. Rodriguez, we contend, was improper because the trial court erroneously determined Ms. Norris's legal status to be that of an uninvited licensee rather than a public invitee. Based upon that incorrect status, the trial court used the lesser standard of care in determining Mr. Rodriguez had no liability. And finally, contrary to the undisputed evidence, the trial court ruled Mr. Rodriguez did not control the portion of his driveway he built within the county right-of-way, which caused Ms. Norris to trip and fall. We contend that summary judgment should have been entered for Ms. Norris because she was a public invitee. The duties that were owed to her were breached. The record describes those breaches. The evidence is uncontested. Mr. Rodriguez admits his driveway contained a known tripping hazard that he knew of for years and did nothing to either warn pedestrians or to repair at any time prior to this fall. And based upon that, summary judgment should have been entered in favor of Ms. Norris, and we would ask for that on remand. So the first issue is Ms. Norris's legal standing, her standing as a public invitee. Public invitee is a person who is invited to enter on or remain on land as a member of the public for the purpose of which the land is held open to the public. In this case, we have a residential neighborhood. Running through it is a roadway, normal configuration. On either side are sidewalks for pedestrians. On either side of the roadway are 10-foot right-of-ways owned by Hillsborough County, which is where they put their sidewalks. In order for pedestrians to reach these sidewalks, they have to walk through the right-of-way. The right-of-way contains within it also driveway aprons so that residents can reach the roadway from their private property. And so pedestrians can walk across these driveway aprons to reach the sidewalk. That is the design.
And Mr. Seifert, the roadway, the driveway aprons, those are owned by the owner of the property, correct?
Correct, Your Honor. Yes, we had 2 county employees that are involved in this process. Both testify that the driveway aprons are owned by the residents. They have to obtain a county permit to install them in the right-of-way. They are required to repair and maintain them, and they can do so in the similar way they install them by getting a permit from the county, in which they can then repair and replace them as they see fit.
And so why should we not follow the case out of the 3rd district of Porto versus Carlisle Plaza to this situation here, that Ms. Norris was an uninvited licensee?
Because the facts in Porto are distinguishable. In Porto, in walking in the right-of-way, the person walking their dog left the right-of-way. They actually entered into the private property of the homeowner. That's where their accident occurred. In this case, there is a 10-foot wide right-of-way from the roadway over to the sidewalk. The driveway aprons are well within that right-of-way. There's no dispute the driveway aprons are within the right-of-way. And at that time, Ms. Norris was in the county's right-of-way. She is entitled to walk anywhere within that right-of-way, similar to the fact she's allowed to walk anywhere within a roadway and crossing it. So in order to do that, the safest place to cross is not through the landscape portion, but is across the driveway aprons, which are built to code, are supposed to be uniform in nature, and are built for vehicular traffic, and thus pedestrians can use them safely, which they do, in which Mr. Rodriguez admitted that's what pedestrians do within his neighborhood. So at no time did Ms. Norris ever leave the county right of way. What happened is Mr. Rodriguez was allowed to build within the county right of way a concrete apron, basically a concrete bridge across county property, get from his property to the public roadway. So that case is factually distinguishable. Because of that, and it's undisputed that Ms. Norris was within the public right of way at all times, and she was invited by the county. And that's the important element, because as a public invitee, she was invited by the county to use the public sidewalk, and she had a right to access it across county land. That she did. Because of that, she was permitted to walk across Rodriguez's driveway apron in order to reach the sidewalk. And we've cited cases, one out of this court, which is Lee County, that talks about if a utility or someone built something within a public right of way, they have to maintain it and build it such that pedestrians can cross over and not be injured by what was built within it. Same thing, that's right of ways are for utilities to be placed in there. And they have to be placed in there by private companies so that they do not injure or damage pedestrians walking within the right of way. Because these right of ways are not for cars. These are for pedestrians to reach over to the sidewalk, because pedestrians have to reach the available sidewalk from the roadway. Thus, they are forced to cross over these right of ways, which in residential neighborhoods either consist of grass maintained by the homeowner or a concrete driveway apron, which is the safest way to cross. Because at all times, Ms. Norris remained within the county right of way, she was a public invitee of the county. She honored that invitation, staying within the county's property and staying within the county's right of way. Because of that, she was misidentified as an uninvited licensee rather than what she was, which was a public invitee. And because she was a public invitee, Mr. Rodriguez, and there really is no distinction between a public invitee and an invitee within the case law, we cited that. The two standard duties apply, the duty to warn and the duty to make safe. These duties apply also in this particular case.
Christy, for the Rodriguez's have position on this is that it was an obvious danger. And it was a portion of the apron that was on the corner that she could have walked, or that a reasonable person at night when it was not very well lit could have walked in the middle of the driveway. What is your response to that?
Well, Your Honor, that invokes the obvious danger doctrine, which is only relevant to the duty to warn. The duty to repair and make safe is an independent duty not affected by the duty to warn or the obvious danger doctrine, which is only a defense to the duty to warn. But addressing that particular standard, the first thing is there was no evidence in the record that Ms. Norris identified this particular tripping hazard, which Mr. Rodriguez admits was a tripping hazard. It was dark, it was at night, she was walking straight ahead, she wasn't running, she wasn't distracted, she didn't have her cell phone. She was waiting for her fiance to get the dog from the house and she went ahead. She merely took a new route, was crossing the street, and she encountered this at night. So first, as to the obvious nature of it, there's no evidence in the record that it was obvious to Ms. Norris at that time of night under those conditions. The second element of it, the obvious danger doctrine, though.
But weren't there some facts that she was familiar with the neighborhood, and that some of these areas were notable to the neighborhood, that she had walked the neighborhood before?
Your Honor, they tried to imply that she was familiar with the neighborhood simply because her fiance lived there, but you're familiar with the areas you walk in a neighborhood that you don't live in. You're not familiar with areas you don't walk in a neighborhood you don't live in. This is the first time she had taken this route. And simply because you've walked left and know what that is, doesn't mean you're going to encounter the same conditions as you walk right. And you also have to have a reasonable expectation that you're going to encounter some type of danger. There isn't any evidence in the record regarding that. Also regarding the obvious danger doctrine, it's not just whether it was obvious, there's a second prong to it. That second prong is whether Mr. Rodriguez could have anticipated the harm posed to the public by his tripping hazard. He did. And what that is, that second part of the obvious danger doctrine, it negates it from being applicable in this particular case, because the onus cannot just simply be on someone that it's obvious. You also have the onus on the owner to not know that this is a dangerous condition to pedestrians, which was negated when Mr. Rodriguez testified that this was a tripping hazard to pedestrians, and that he understood and knew pedestrians crossed over driveway aprons to get from the roadway to the public sidewalk. So the focus on whether this was obvious, there's no record evidence of it to Ms. Norris. This is a new path to her. She hadn't crossed over it 15 times. The second element of it is the second prong wasn't met by Mr. Rodriguez, because he admitted that he understood that this was a tripping hazard, which means it's he anticipated the harm to the public, that they would trip based upon this broken concrete, which he allowed to exist for years. This wasn't a new condition. He had superior knowledge rather than Ms. Norris, and it was obvious to him, and he took no effort to warn. Merely spray painting a fluorescent line on the crack would have done it. That would have satisfied his duty to warn, to do anything to the public to let them know. And you can't expect that everybody in your neighborhood lives there. You have visiting public. You have people that go jogging different paths all the time. You have people over holidays. You have small kids and elderly people. So however Ms. Norris crossed, there's nothing in the record that says you can't cross into a right-of-way at any point, at any time, from any location, because that's what right-of-ways are. They're public property. And by invitation of the county, Mr. Rodriguez was allowed to put in this concrete structure. So he had the duty to maintain and the duty to warn. And the obvious danger doctrine was not sufficiently inquired into by the trial court. The trial court just said it looks obvious. It did not look at the knowledge that Mr. Rodriguez had, and his knowledge that he should have anticipated the harm the tripping hazard posed to the public, because he did admit it was a tripping hazard. And that really is the elemental fact. Mr. Rodriguez had superior knowledge this was a tripping hazard to the public. So having satisfied, we believe, both of those, and for any reason the court says, well, I don't know that the duty to warn is applicable here, that's fine. We still have the duty to make safe, which is an independent duty. And that duty on its own carries the case for the plaintiff. But having satisfied, we contend both of those duties, there's no evidence that Ms. Norris was comparatively negligent. She was walking straight ahead. She was looking where she was going. This was dark. It was at night. It wasn't lit well. She was going in a new direction, but she wasn't distracted. She didn't have her cell phone. There's no evidence that she was in any way comparatively negligent, or that a reasonable jury could infer this. Finally, at the end, control over the driveway. The trial court also found that Mr. Rodriguez did not control his driveway because he had to get a permit to fix it. But that's not the standard for control. He had the ability to get a permit to fix it. County employees testified all he had to do was apply for the permit. It's routinely granted because they want these structures within their right-of-ways maintained for pedestrian safety. Mr. Rodriguez simply didn't apply for it, even though he knew this driveway apron was in the county right-of-way. It really negates a lot of his case.
Would he have would it have required a permit for him to put some spray paint on the?
No, Your Honor. No, the only thing you need for to do anything, because there are utilities that flow underground within these right-of-ways. So anything structurally that may hit, impair cable, electricity, water that are also buried within these right-of-ways, you've got to get a permit if you want to do anything with the concrete portion.
Right, so he needs a permit to alter the condition, but he doesn't need a permit to warn.
No, Your Honor. No. And the permits given to repair are routinely granted because the county understands that they have sidewalks that people need to walk on, and they want these owners of these properties that are placed within the right-of-way under permit to maintain them, because if they abandon them, the county is left with an untenable situation. So at the summary judgment hearing, Mr. Rodriguez did admit that he exercised the ability to control this portion of his driveway. On appeal, there's a little different approach to that. However, as we stated, the evidence proves, just like he had to obtain a permit to place the concrete apron within the right of way, he could have gotten a permit to repair his concrete within the right of way. County says that's routinely granted. He didn't even apply for that, even though he knew about this tripping hazard. So that argument that he didn't have control over this, we believe, is abrogated by the fact he took no effort and was never rebuffed or rejected by the county because he took no effort to repair it at all. So based upon those facts, we contend that our motion for summary judgment should have been granted. Mr. Rodriguez's motion for summary judgment should have been denied. And we would say on remand that in addition to the reversal, the trial court should be instructed to enter summary judgment on behalf of Ms. Norris. And I'll reserve the remainder of my time if there's no additional questions from the panel. Thank you.
Thank you, Mr. Seifert. Ms. Edelstein.
Well, I guess it's almost good afternoon, Your Honors. Lara Edelstein on behalf of the appellee. We're asking the court to affirm all of the trial court's rulings granting my client's motion for summary judgment and denying the appellant's motion for summary judgment. The trial court properly found that Norris was an uninvited licensee on Rodriguez's property, and because she came to the property for her own convenience. The definition of an uninvited licensee is someone who comes to the property for their own convenience, and there's been no invitation either expressed or implied. Here, the complaint and the allegations in the complaint are that the plaintiff came to the defendant's property and that the defendant was the owner of the property. There was no allegations regarding the county property, the county right of way, nothing like that. They did allege that she was a public invitee, but apparently, according to the allegations of the complaint, it was on Mr. Rodriguez's private property. So all of the arguments related to the county property, the county right of way that were made in the motion for summary judgment, as well as at the hearing and certainly on appeal, really were not framed by the pleadings. And so they really should not have been considered by the trial court. What we have here is at the corner of the driveway, and I actually hesitate to say driveway. I was looking at the photographs again in preparation for today's argument. And if the court would like to look at those photographs, they're at page 305 to 310 of the record. And they clearly show that the area that the appellant identifies as where she fell is actually the curb. It's really, it might be the white concrete that's similar to the driveway apron, but it's really at the curb next to the mailbox. And in looking at the photographs as well, the court will notice that the roadway, the darker cement that leads up to the driveway is actually, looks like it's broken, it's very gravelly, and the plaintiff, Ms. Norris, never testified exactly where she fell. Her deposition testimony, and I quote, is, "All I know is I crossed the street and the next thing I know, I was on the concrete. And I remember kind of like being dazed." And that's at page 546 through 547 of the record. There's no other testimony by Ms. Norris as to where she fell, how she fell, where she landed, which foot she used. Nothing. She says she walked across the street and then she was on the concrete. So after the fact, it seems that she's decided that that's exactly where she fell, but there's been no other direct evidence that that's where she fell. She also testified that she was bleeding a lot and that there was blood everywhere. But then when asked if there was blood on the concrete, she said she didn't know. And there's been no evidence by Mr. Rodriguez or anybody else that there was any blood or anything on the sidewalk that anybody saw, or that on that portion of the driveway.
That's not the basis of the summary judgment, was it?
That's correct, Your Honor, but summary judgment standard of review is de novo, so this court can look at anything in the record in order to determine whether or not the order should be affirmed. And getting back to the uninvited licensee, the trial court correctly found that the condition of the driveway was open and obvious, if we're going to call it the driveway. It was open and obvious. And the other part that goes to this is that Ms. Norris, although she didn't live at her boyfriend's property, Apparently she stayed there regularly, and she claimed that she walked the dog with him at least 5 to 10 times while she would visit with him. And apparently the county employees testified that this problem with the oak trees, lifting of the sidewalks and roadways, was throughout the community and even throughout the county. One of the county employees testified that there were thousands of linear feet of sidewalk that needed to be replaced throughout the entire county. So even though Ms. Norris might not have ever walked in front of Mr. Rodriguez's property, she was on notice that the sidewalks in the community had issues with these oak tree roots. And so, nevertheless, she could have used due care in watching where she was going in order to walk across the street.
Ms. Sadelstein, does your position change if we were to find that she was a public invitee versus an uninvited licensee?
Well, certainly the duty to warn doesn't change, and obviously under a public invitee status, the defendant would have a duty to maintain the property in a reasonable condition. Now, Mr. Rodriguez testified that, first of all, the county planted the trees at the outset of the, the development of the community, and that the county had years earlier come in and fix the sidewalks and trim the trees, trim the tree roots. And he also understood in 2017 through word of mouth in the community and also through his own internet research that the county was coming. They were accepting bids for the work, and that the county was going to be working on the property. And in fact, unfortunately, after the accident, the county did come and fix the areas in Mr. Rodriguez's yard as well as throughout the community. Again, those pictures are at 305 through 310, and it shows exactly where the county fixed the sidewalk, fixed the driveway, and actually removed the tree in question. And so Mr. Rodriguez acted reasonably in taking care of his property and in knowing that the county was coming to fix the sidewalks in the community. He didn't know exactly whether or not his house was involved in the county's plans, but he understood that it was happening. I don't know what else he could have done. He could have gotten a permit to fix it, but I'm sure that would have taken hundreds, if not thousands of dollars to fix all of that concrete and remove the tree. And so I'm not sure that he was under the duty to do that to reasonably maintain the property. Again, the corner of this property where it's alleged that she stepped is so close to the mailbox that Mr. Rodriguez would never have a reasonable expectation to foresee that anybody would walk up to that spot right there, especially where, as you can see in the photographs, the driveway is 2 or 3 car wide driveway with plenty of room to walk. So he would never have expected that somebody would come to the property and step up right next to the mailbox. There's just no purpose for that. In addition, Ms. Norris testified that when you're facing Mr. Rodriguez's home, and she was coming from her boyfriend's home, which was to the left, and so she was walking from the left to the right, and that she was going to cross Mr. Rodriguez's property to the right and go that way because the lighting was better. She testified that the reason why she chose that route on that night was because Mr. Rodriguez's home had lights on it that were emanating more light than anywhere else in the neighborhood. And so interesting that she claims that she couldn't see the curb when she also testified that it was the lightest area on the street. But nonetheless, she was walking from left to right, and that piece of the driveway is at the leftmost corner of that driveway. So why she wouldn't, take another step into the main area of the driveway is just an unreasonable and unforeseeable instance that Mr. Rodriguez would not have been required to maintain that specific spot on his property. And this argument about spray painting the area, that was never raised in the trial court, and it's not a part of the record. And I don't know how this court could consider that in its decision today. Going back to the uninvited licensee status, The trial court properly found that Mr. Rodriguez did not engage in willful misconduct or wanton negligence or in intentional conduct exposing Norris to danger. Again, like I said, he understood that the county was coming to fix the roadway and the sidewalks. They had done it in the past, and he didn't do anything intentionally to cause the condition to happen. If you take a look at the photographs, you'll see that most of the sidewalk, not his driveway in particular, but the sidewalk was cracked as well. But again, it was throughout the community, and it wasn't anything on his part that he did to create that condition. And lastly, the condition was open to the ordinary observation of the licensee. Clearly, Norris was walking towards that area because it had better light. She should have been paying attention. There's no reason to think that she could not have seen that broken piece of concrete had she been paying attention and looking where she was going. It was open to her ordinary observation. And so based on those elements, the trial court correctly found that she was an uninvited licensee. And going to your question, Judge Smith, about the Porto case, that is directly on point. Interestingly, she was also walking a dog, but she walked from the public sidewalk to a private area of grass for the dog to relieve itself, and then was walking back to the public sidewalk when she tripped over a piece of metal that apparently was left over from an old fence or something to that nature. And the trial court found—
But to Mr. Seaford's point in Porto, the injury took place on the owner's property in the grass, I think in the grassy area, versus here, this is in the actual right of way of the county. Would that not be a distinction?
I think it's a distinction without a difference. Again, I think he goes back and forth between this whole county right of way issue. I don't think it makes a difference because, you know, again, she should have been paying attention to where she was walking. There was no duty to warn. There was, you know, nothing that Rodriguez could have done to correct the situation without, you know, getting the county involved. And I do think that, like the plaintiff in Porto, where she was coming onto the property for her own convenience, the same applies here. Norris was coming to the property for her own convenience. She was not there by invitation of the county or Mr. Rodriguez.
But to be fair, the only way she can get to the sidewalk is by virtue of the driveway aprons. Am I right?
That's correct, Your Honor.
Okay, so I mean, it's not a trespass or anything like that. I mean, they have to, that's the purpose of the right of way, is so they can get to the public sidewalks.
I agree with that, Your Honor. And
Doesn't the law hold, for instance, like if there was in a situation where you have a walkway from a front door out to a street or sidewalk, there is an implied invitation to the public to walk up that sidewalk, I mean, that walkway?
I do think there is an implied invitation on the
Why
sidewalk.
isn't there an implied invitation here where the driveway or in the apron is actually on a public easement, on a public right of way?
Well, again, Your Honor, the issue here is that wasn't the way that the pleadings were framed.
Yeah, but that's how your motion for summary judgment was framed. And so it's such that you were claiming essentially as an affirmative defense that the plaintiff was a trespasser or at most an uninvited, an invitee. So, and so you have to file a motion for summary judgment that sets forth your theory. And it seems to me that whether the pleadings said that or not, it's not the issue at this point. You're asserting a defense in that motion for summary judgment.
Your Honor, I would agree with you that the trial attorney did argue that she was a trespasser. I don't agree with that. But she, at the end of the motion, she said at best she was an uninvited licensee. And I do agree
Okay,
with that.
there you go. And that was in the motion for summary judgment.
That's correct.
Your theory.
But that's correct. But I still don't agree that necessarily means that the plaintiff gets to now change this status and change the fact that the property is owned by the county and not by Mr. Rodriguez.
Well, that's
So-
not, I don't think that's what the argument is. I think the argument is that it's his property, but it's in the county right of way. And as a member of the public, she has the right to be on that right of way.
I agree that she has the right to be on the right of way, but that doesn't mean that Mr. Rodriguez was responsible for her injury. The plaintiff specifically and vehemently at the trial court hearing discussed that they weren't naming the county in the case, and so they could have gone after the county, but they didn't. There was never a motion to amend to include the county as a
But
party.
did the county build the driveway? Does the county own the driveway?
The county owns the property, and I understand that the developer.
Actually, I don't think the county owns the property just because it has a right of way. I think it's the county has a right of way on property that your client owns, and your client owns a driveway that is on the county right of way. Isn't that how it works?
Well, I understand what you're saying, Your Honor, but the testimony by the county employees was that it was the county property and that the developer of the community was, I guess, given access to build the driveways, and that it's that the concrete and the driveway belong to Mr. Rodriguez, but that it's on county property is the way that they addressed it. So in any case, I don't agree that Ms. Norris was necessarily a public invitee, because she came to the property for her own convenience. And so, and there, if we're going to talk about Mr. Rodriguez's driveway, he didn't make any invitation for people to walk there. And in fact, the definition of an uninvited licensee talks about that their presence is neither sought nor forbidden, but merely permitted or tolerated by the landowner, which is what we have here. I mean, typically a homeowner can't tell somebody else that they can't be on the sidewalk, but they, if they were in their driveway per se, then, the homeowner could say that they weren't invited there. But a landowner tolerates it or permits it, but not necessarily, it's not forbidden, but it's not an absolute invitation, to be there. And so I think that she falls squarely into the definition of an uninvited licensee. I think that we can also argue that the condition was open and obvious and open to her ordinary observation. She should have been paying attention to where she was going, certainly in light of the fact that she claimed that this was the lightest part of the street and that was why she was going there in the first place. So she should have been able to see it. And so under either standard, there wouldn't have been a duty to warn her of the issue, because she should have exercised due care in watching where she was walking, especially because she thought it was dark and that she was going towards a lighted area. So she should have been paying more attention and exercising due care in that manner. And, the last part of our brief, we talked about the fact that the plaintiff's presentation of evidence, where she has the persuasion of burden at trial, was lacking here, because she never testified to exactly where she fell. She didn't know exactly what happened. She said she crossed the street and then she was on the concrete. So she didn't know where she stepped. She didn't know which foot she used. She didn't know where she fell. And there was no other testimony regarding that. So she basically improperly stacked inferences in order to come to this conclusion that she was standing on that piece of concrete, that concrete caused her to fall, and that Mr. Rodriguez was responsible for her fall. And so based on an improper stacking of inferences, the trial court was eminently correct in granting summary judgment in my client's favor. Just looking at my notes. I guess if there are no other questions, I don't have anything else. Thank you, and we ask that the court affirm the summary judgment.
Thank you, Ms. Edelstein.
Thank you.
Mr. Seifert, you're up.
Yes, Your Honor.
You asked for 3 minutes, but you didn't use all your time. So how about taking 5?
Thank you, Your Honor, and I will use the 5.
Mr. Seifert, I'm going to ask you a question right off the bat here. Can you address the issue of foreseeability of the injury, whether or not the injury that occurred here was foreseeable so that the Rodriguezes are liable for not maintaining?
Yes, Your Honor. I think it's by Mr. Rodriguez's direct testimony. He identified the broken concrete. It was 1.5 inches above all the surrounding concrete. It was on his driveway. He knew individuals traversed it to get to the public sidewalk because, as you've noted, how else do you get to the public sidewalk? You have to cross.
Well, I mean, let me give you an example of something that would be foreseeable injury. If someone had previously tripped on that driveway apron.
Your Honor, I think the notice was Mr. Rodriguez's common sense. You didn't need a prior occurrence to know that this was a tripping hazard. And even Mr. Rodriguez, a layman, identified it as a tripping hazard. And a tripping hazard existing on a concrete walkway is going to result in injuries to whoever falls, and that's foreseeable. That's not something you need an expert for. And in fact, no expert was required on the issue of whether this is a tripping hazard or not, because Mr. Rodriguez admitted it was a tripping hazard. The elevated concrete was 1.5 inches above the surrounding areas. There's a bit of a, I think, red flag talking about the pleadings. The pleading said Mr. Rodriguez's property. That encompasses his concrete driveway. That driveway is the property of
Yeah,
Mr.
but
Rodriguez.
I'm glad you raised that. So let me go back to the testimony because Ms. Edelstein reminded me that the testimony from Christopher Snyder, who's employed by the county, as well as Otis Holler, who's employed by the county in the public works, they all say that the right-of-way was owned by the county. And in fact, I think Snyder says that that portion of the driveway was owned by the county. Now, I tend to agree with Judge Northcutt that the property owner owns the property and there's a county right-of-way. Are we going to get... but you know, both of these individuals from the county are saying this is county property. So how are we supposed to reconcile that, Mr. Seifert?
Your Honor, I'm not smart enough to tell you how to reconcile that because there are record facts which are not in dispute by 2 county employees. I understand there is case law out there or knowledge that may be contrary to that, but it may be however they perceive it in this area. The reality is there's no.
Well, doesn't that, but doesn't that
Can
cut
I
in?
suggest a way we can reconcile it for these purposes?
Yes, Your Honor.
This was a summary judgment, and that was not the theory of the motion for summary judgment.
Correct, Your Honor. And
The law
also
requires that the theory be set forth in the motion, and the motion for summary judgment did not deny ownership.
at no time, and nor did they deny that it occurred on the driveway. That's why there is no Fabry defense bringing in the county. There is no allegation by Mr. Rodriguez that the county was in any way responsible for anything that happened related to this lawsuit because there is no Fabry defense that was pled. As to Ms. Norris identifying where she fell to address that issue, she wasn't asked because it was understood by the parties exactly where she fell. There was no dispute between the parties as to the location of her fall or the instrumentality of it, or that it was a concrete tripping hazard on Mr. Rodriguez's concrete apron. She can only respond to the questions she's asked, and she was deposed by the defendant. If they wanted to inquire into all these areas that Ms. Edelstein is now identifying, they had the opportunity to do so, and they did not because they understood and implicitly agreed that this was not contested as to where she fell. It was just about control over the place that she fell. We keep, I think there's evidence that's not in the record that's been addressed on argument that it would have cost Mr. Rodriguez hundreds of thousands of dollars to repair this. No evidence to that nature. Mr. Rodriguez never even got a quote. Mr. Rodriguez never took any action.
Nor is what was a reasonable repair asserted as a ground for summary judgment.
No, Your Honor.
Summary judgment, as far as I can tell, is just based on your client's status and whether this was an observable condition.
It was based upon status It was based upon the two duties, the duty to repair and make safe and the duty to warn.
But their contention was they didn't have either one because of your client's status. There was no question of, well, the repairs to make it safe would have been an unreasonable. I mean, that wasn't a theory.
Correct, Your Honor, they never addressed that and they never raised it because they were going to stand and die on either she was an uninvited licensee or a trespasser. And they were not going to address nor refute factually the argument that she was a public invitee owed these two duties. So if there is an absence in the record of addressing these issues, it is by a deliberate.
Well, you know, that my point is that we are not here on a summary judgment on any of those bases other than her status. And we're
Correct.
not here on a verdict, you know, whether there's substantial competent evidence at a trial on any of these issues. And, you know,
Correct, Your Honor.
although the appellee suggests we can affirm on any ground, I don't think that's true in a summary judgment. I think what we are limited to and what the movement for summary judgment is limited to is a theory asserted in the motion for summary judgment, because they have to, under the rules of civil procedure, they have to file the motion for summary judgment, state their theory, and give the other side an opportunity to respond. And that first opportunity to respond can't be on appeal. Correct?
Agreed, Your Honor.
I knew you would say that.
Also, and last thing, Ms. Edelstein keeps referring to photographs in the record. If the photographs in the record have any validity as to what the trial court did, those are questions of fact to be resolved by a trier of fact in looking at the photographs, and not for any other purpose, because they cannot be interpreted any other way. But in fact, those photographs were not a significant element of their motion for summary judgment. The court talked about lighting, but that was through testimony of Ms. Norris. However, if the court deems that the photographs are instrumental in evaluating the summary judgment, then it means the summary judgment has to be reversed, because the photographs cannot be interpreted as a matter of fact statically. They can be interpreted by a jury as a trier of fact.
Okay,
So
Mr.
for all
Seaver, you need to wrap it up here.
And Your Honor, I am wrapped up. So we would request that the summary judgment be reversed, and I thank the court and its panel for its time.
Thank you both very much. In order to leave our virtual courtroom, you click the button that, interestingly enough, is called leave on the Zoom screen, and you'll be off into the ether.
Thank you.
Hey, thank you both. And let's see if we can get our case that we skipped back up with Mr. Smolker and Mr. Zeller.